closing arguments in the defamation case against Donald Trump are underway in a New York federal court. But here's some of the latest. Court started 10 minutes late with the judge asking Ms. Habba, is your client intending to be here this morning? He's talking about Donald Trump. My control room just got in my ear saying that Donald Trump also just walked out of court in the middle of closing arguments as the prosecution is up first. Carroll is seeking more than $10 million in damages from the former president. And before the jury walked in, there's a lot going on. The judge reminded everyone that they have to stay quiet during closings, saying this, quote, there are to be no interruptions by anybody, no audible comments by anybody else. And now Trump, we know, has walked out. Joining me now to talk more about this is former federal prosecutor Renato Mariotti. Renato, there's a whole lot going on in this is closing arguments. I mean, you've got Habba being asked if Donald Trump is going to show up. He shows up 10 minutes late. The judge warning everybody to not have disruptions. And then I'm just hearing in my ear that Donald Trump has walked out of court.
While the cameras locked on Donald Trump storming out of the courtroom, something far more dangerous was already happening at the counsel table. Trump's own lawyers looked a United States district judge dead in the eye and lied under oath. They didn't lose a file. They didn't miss a deadline. They made a deliberate, calculated choice to hide documents the court had ordered them to produce, and then they swore those documents did not exist. When the truth finally cracked open under relentless questioning, the entire temperature of the room collapsed. The judge's voice changed. The professional mask vanished. And in a move almost never seen in modern federal court, he ordered the immediate arrest of Trump's lawyers right there in open court while the official record was still rolling. The circus just turned into a crime scene, and the men and women who spent years covering for Donald Trump are about to learn the hard way. Loyalty to him does not buy immunity from handcuffs.
All of a sudden, inside the closing arguments in the defamation damages trial against Donald Trump. Trump walked into the courtroom late. He walked out when the plaintiffs were delivering their closing arguments. At one point, the judge had to warn defense lawyers they were close to being thrown in the lockup. Let's get right to CNN's Carroll, who ran out from inside that courtroom to give us an explanation of what was going on. Kara, what have you been seeing?
Yeah, John, an eventful day this morning, to say the least, that had nothing to do with even the closing arguments. So it began, as you say, when Donald Trump's team was already late, which the judge noted when he took the bench. Then Donald Trump did enter the courtroom, and they were arguing still, before the jury even got in there, about a slide that Trump's team wanted to use in their presentation. And Carroll's lawyers said it included things that were not in evidence in the case. The judge said it was out. That's when Trump's attorney, Alina Habba, stood up to challenge the judge on his ruling. He's made it very clear throughout this trial, when he rules, and that's it. She started to challenge him. He had hit his limit and said, you are on the verge of spending some time in the lockup. Now sit down. Now, then at this point, we were moving into closing arguments. The jury was brought in.
That warning about being taken into custody was presented as far more than an empty threat. According to the narrator, it marked the breaking point in a dispute that had been building for months. What followed was no longer an ordinary procedural disagreement. After sustained and direct questioning from the judge, one of Trump's attorneys reportedly acknowledged that the documents the court had ordered to be produced did in fact exist. The lawyer admitted they had been aware of those records, had intentionally chosen not to produce them, and had then stated under oath that the documents did not exist. The narrator argues that the public rarely sees how conduct like this can accumulate over time. Every missed deadline that goes unaddressed, every court order that is ignored, and every inaccurate statement made under oath gradually weakens the authority of the court. It also undermines the discovery process, the legal mechanism designed to ensure that both sides disclose relevant evidence so the truth can be established. According to the narrator, experienced judges recognize these tactics because they have encountered similar patterns across numerous cases and in courts throughout the country. What made this moment different, the narrator contends, was that the alleged withholding of evidence could no longer be denied once it was examined in open court. When a federal judge reaches the point of ordering the immediate arrest of counsel, the issue is no longer limited to a single document or a single hearing. Instead, it becomes a broader question of whether the rule of law is enforced equally, even when the client is a former president who has repeatedly argued that the legal system is being used against him. According to the narrator, the court's response left little doubt about its position.
Are closing arguments normally this eventful?
No, but I will say that one strategy, Kate, that defense counsel use sometimes, even in criminal trials, is to try to distract the jury when the prosecution is giving their closing argument. I think that, part of what's going on here is there's an attempt to create a circus, distract from the evidence, distract from all of the comments that Trump has made in the past that are coming back to haunt him here. And so, I think part of why he's arriving late and he's coming in and out is partly to keep the jury focused on him rather than the arguments that E. Jean Carroll's attorney, Robbie Kaplan, are making.
A couple things here. He wanted the attention on him definitely yesterday for that. I mean, it was like a momentary period of time that he took the stand. What do you think he and his legal team got out of it? What do you think the impact of Donald Trump being on the stand will be?
He was being put on the stand to try to slip in some comments to say that essentially he didn't do this. He didn't actually sexually assault E. Jean Carroll and so on. That is not legally relevant. The jury in a prior trial already found that he did do that. But nonetheless, there's an attempt here to almost try to nullify the law, to have the jury return a verdict that's not consistent with the verdict, for example, in the prior case. And the judge had no part in it. That's why it was so short, Kate. That's why the judge shut it down very quickly.
What may appear to be chaotic courtroom behavior is presented here as a deliberate legal strategy. Arriving late, leaving the courtroom during arguments, and taking the witness stand only for carefully selected moments are described as calculated moves intended to shift attention away from the evidence and focus it instead on Donald Trump himself. According to the narrator, the objective is straightforward: make the trial about Trump's presence rather than the facts being argued in court. The narrator then argues that there was another layer to the strategy that received far less public attention. According to several attorneys who were reportedly present that day, Trump's legal team had prepared a backup plan if the courtroom theatrics failed to achieve their goal. That plan, the narrator claims, involved introducing last-minute material that would not be admissible as evidence, with the intention of creating grounds to argue on appeal that the proceedings had been unfair. In other words, if they could not prevail at trial, they would attempt to create issues that could later be used to challenge any unfavorable verdict. The account then turns to what was allegedly happening behind the scenes at the same time. While Alina Habba was reportedly being warned about the possibility of jail, members of Trump's legal team were said to be working urgently to prevent the release of internal emails. According to the narrator, those emails contained direct discussions about intentionally withholding important documents in a way that would disadvantage E. Jean Carroll's legal team. A source described as familiar with the proceedings also claimed that the judge had already reviewed portions of those emails before issuing his ruling. According to the narrator, that conduct goes far beyond ordinary legal advocacy.
Let me just read to you what Ms. Kaplan was saying as Mr. Trump rose to walk out. She said that his followers made good on his initial threat that she should pay dearly and that she should tread carefully. She then went on to say Trump behaves as if rules don't apply to him. She said that he continues to defame Ms. Carroll even as this trial is ongoing, and that for the rest of us, if we were found liable of a crime, we would stop, and that he doesn't. At that moment, Mr. Trump rose from where he was seated, left the room. The judge then said, let the record reflect that Mr. Trump has left. The closing argument continued, and Mr. Trump would eventually return for the closing argument of his defense team, led by Alina Habba. But the tension in the courtroom this morning, Lana, was thick, especially considering Trump's team was late to arrive.
According to the narrator, Trump has consistently acted as though the rules do not apply to him. The narrator argues that this was not merely political rhetoric, but a reflection of how his legal team was conducting itself in court. While E. Jean Carroll's attorney told the jury that Trump continued to resist accountability for his own actions. Trump stood up and left the courtroom. At the same time, the narrator contends his attorneys had already been accused of disregarding the court's discovery orders in a similar fashion. What makes this episode significant, according to the narrator, was not Trump's departure from the courtroom, but the judge's response afterward. A federal judge does not order the immediate arrest of counsel without extraordinary circumstances. Such action, the narrator explains, is generally viewed as a last resort after lesser measures, such as warnings, financial sanctions, or formal referrals, have failed to produce compliance. In this account, the court determined that those lesser remedies were no longer sufficient. The narrator argues that the effects of that decision would extend far beyond a single hearing. From that point forward, every filing submitted by the legal team, every request for additional time, every statement regarding evidence, and every assertion of good faith would likely be examined with far greater skepticism. According to the narrator, the level of professional credibility that attorneys typically receive from the court had been seriously damaged. The narrator concludes by arguing that Trump spent years encouraging his lawyers to view court proceedings as obstacles that could be delayed, challenged, or diverted. In this telling, those same attorneys were now learning that the legal system also has the power to respond forcefully, and that unwavering loyalty to a client can carry personal legal consequences.
Olivia, I want to hang on what Trump did earlier, walking out of the courtroom in the middle of those statements there. This is not the first time that we've seen drama in this courtroom in terms of this case here. We've seen outbursts, the judge, struggling at times to kind of reel him in. Curious, what impact overall could Trump's conduct have on this case against him?
Well, remember, the jury is seeing all of this. Every single time Donald Trump scoffs, every single time Donald Trump shakes his head, every single time Donald Trump gets up to leave the room, the jury is seeing it. And this is actually the first time that Donald Trump has been in front of a jury. He didn't go to the first trial against Jean Carroll. He never attended. And his civil fraud trial related to his business is a bench trial. There is no jury. So this is the first time a jury is looking at Donald Trump and observing his conduct. And they are very likely seeing what everyone in that room is seeing, is that he's not happy about what he's hearing. He appears at times livid, especially every single time it is referenced that he has been found guilty of sexually abusing Jean Carroll.
The jury witnessed every moment unfold, every look of frustration, every shake of the head, and every dramatic departure from the courtroom happened in full view. According to the narrator, this marked the first time in these legal proceedings that a jury of ordinary citizens sat in the same room as Donald Trump and watched him openly challenge the authority of the court overseeing his case. They saw a man who had already been found liable for sexual abuse react with visible anger whenever that ruling was referenced. They also watched him treat the proceedings as though they were an inconvenience rather than a formal judicial process. At the same time, the narrator argues, the court had already concluded that Trump's attorneys had crossed a professional line that most lawyers never approach. According to the narrator, this was never simply about one courtroom exit or one heated exchange. It represented the culmination of a strategy that had been employed over several years, one that treated federal court procedures as obstacles rather than binding obligations. The approach, the narrator claims, remained consistent across different courts and different cases. Delay deadlines whenever possible, challenge every ruling, overwhelm opponents with extensive filings, and, when necessary, conceal information. For a considerable period, the narrator argues, those tactics appeared to succeed. Hearings were delayed, cases moved more slowly, and outside political events had additional time to influence the broader landscape. But that strategy depended on one crucial element, the credibility of the attorneys appearing before the court. According to the narrator, once that credibility is lost, the entire strategy begins to fail. The narrator explains that when a federal judge orders the immediate arrest of counsel in open court, the usual assumption that attorneys are acting in good faith is fundamentally damaged. From that point forward, every filing submitted by the legal team, every request for additional time, every statement regarding the existence of documents, and every claim about efforts made to locate evidence is likely to receive heightened judicial scrutiny. In the narrator's view, the benefit of the doubt has been exhausted. The potential consequences for the attorneys themselves are described as both serious and long-lasting. Contempt of court, the narrator notes, is not merely symbolic. Federal judges possess the authority to impose fines or order incarceration until the contempt has been resolved. According to this account, if such orders were carried out, the attorneys could face ordinary detention rather than any special treatment, remaining in custody until the court determined that the obstruction had ended. That would require producing any withheld documents, providing truthful testimony about the underlying events, and demonstrating full compliance with the court's directives. Continued refusal, the narrator argues, could result in confinement lasting indefinitely because courts possess those powers to ensure that their orders cannot simply be ignored. Beyond contempt proceedings, the narrator points to the possibility of professional discipline. Every state bar association enforces ethical rules requiring complete honesty toward the court, and making false statements under oath is among the most serious violations an attorney can face. According to the narrator, when a federal judge places findings of deliberate deception on the official record, disciplinary authorities are likely to take notice, making formal investigations highly probable. If those investigations ultimately support the court's findings, the consequences could include suspension from the practice of law or permanent disbarment. For attorneys who have devoted decades to building their careers, whose professional identity and financial future depend on maintaining a law license, disbarment is often viewed as the ultimate professional penalty. The license is lost, the practice comes to an end, and the reputation built over years can be permanently damaged. The potential legal exposure extends even further. Obstruction of justice is a federal felony. Perjury is a federal felony. Making false statements during a federal judicial proceeding is also a federal felony. Convictions for these offenses can carry substantial prison sentences. Federal prosecutors have broad authority to pursue criminal charges when evidence of unlawful conduct emerges during court proceedings. According to the narrator, the evidence in this instance is unusually straightforward. An official hearing transcript in which a sitting federal judge concluded that attorneys had engaged in deception and obstruction. The narrator argues that such a record could provide prosecutors with a direct foundation for further action because many of the underlying facts are already documented in the court's own proceedings. For Donald Trump, the narrator contends, the implications reach even further. His legal strategy across multiple cases has consistently relied on delay, filing motions, appealing rulings, challenging procedural decisions, extending deadlines whenever possible, overwhelming opposing counsel with litigation, and hoping that time or political developments ultimately change the landscape. The narrator acknowledges that this approach has achieved tactical successes in the past, delaying trials and slowing legal proceedings, but the strategy also depends on maintaining at least a basic level of credibility with the courts. Judges must be able to rely on attorneys' representations as truthful. According to the narrator, this incident suggests that reserve of credibility has now been exhausted. Judges are no longer expressing only skepticism. They are, in this account, making formal findings of dishonesty and issuing extraordinary courtroom orders. Every future interaction with the judiciary, the narrator argues, will occur under the shadow of those findings. The narrator also emphasizes that this pattern is not limited to a single case. Across multiple jurisdictions and proceedings, federal judges have issued warnings, imposed financial sanctions, and criticized delay tactics and discovery-related conduct in written opinions. In the narrator's view, judicial patience has been wearing down for years, and this courtroom episode represents the point at which accumulated frustration resulted in concrete and far more serious consequences. The significance, according to the narrator, extends beyond any one defendant or legal team. The judicial system functions on trust. Courts depend on attorneys to speak truthfully and on parties to comply with lawful orders. When that trust breaks down and judges begin operating from a presumption of dishonesty, the narrator argues, the justice system itself becomes less effective. Cases that should focus on the underlying facts instead become consumed by disputes over credibility. time and judicial resources that should be devoted to resolving legal issues are redirected toward determining whether participants are telling the truth. As a result, public confidence in the courts can also suffer. The narrator argues that if those participating in the legal process cannot be trusted to act honestly, the courtroom risks becoming a place of manipulation rather than one of justice. For years, Donald Trump has maintained that the rules are applied differently to him and has encouraged supporters to challenge established institutions. According to the narrator, the events of this hearing demonstrate that a federal courtroom remains capable of enforcing its authority. The reported arrest orders are presented not simply as punishment, but as a statement that judicial authority is not optional, even when the client is a former president whose public image has often centered on defiance. In the narrator's view, the attorneys who chose to support that strategy are now confronting the consequences of those decisions. Some may face the possibility of incarceration. Others could face lengthy disciplinary proceedings that threaten their ability to continue practicing law. All, according to the narrator, will carry the lasting impact of being associated with extraordinary judicial findings concerning dishonesty and obstruction. For Trump himself, the narrator concludes, the greatest damage is strategic. The delay strategy that once operated effectively is now viewed through a lens of heightened suspicion. Future motions may receive closer examination. Future representations are likely to face more rigorous verification. The room for error has narrowed considerably. This, the narrator argues, is what happens when a defendant and the attorneys representing him treat judicial authority as another obstacle to overcome instead of a legal boundary that must be respected. Eventually, warnings become formal orders. Eventually, orders carry meaningful consequences. The jury witnessed the alleged defiance. The judge placed the findings on the record. According to the narrator, the consequences are now part of the official proceedings, and the story is far from over. If you found this analysis valuable, be sure to subscribe and turn on notifications. More coverage is coming on the aftermath of this hearing, the disciplinary referrals reportedly under discussion, and the broader pattern of judicial findings involving Donald Trump and the attorneys representing him. Be sure to watch the next video on your screen for the next chapter in this story.